Welcome to today's event, the Relevancy and Reach of the U.S. Sentencing Commission. I am Tanya Bennett, Director of Programs for Criminal and Civil Justice for the American Constitution Society for Law and Policy, otherwise known as ACS. For those not familiar with ACS, we are a national network of lawyers, law students, judges, and policymakers who believe that the law should be a force to improve the lives of all people. ACS works for positive change by shaping debate on vitally important legal and constitutional issues through the development and promotion of high-impact ideas. The U.S. Sentencing Commission is charged with various federal crime and sentencing responsibilities, but it is best known for promulgating the federal sentencing guidelines. The guidelines turned 25 this year, having been implemented on November 1st, 1987. And like on all anniversaries, we ask, have sentencing guidelines gotten better with age? Proponents of the current guidelines will answer yes, perhaps offering that the guidelines are better as a result of U.S. v. Booker, a U.S. Supreme Court decision that made the guidelines advisory. Opponents will disagree, arguing that the advisory guidelines have resulted in the judicial discretion and inconsistent sentences the guidelines were meant to correct. The positions on the commission itself are just as varied. Some argue that the commission is more relevant now than ever, applauding its decision to make new crack cocaine sentencing guideline amendments retroactive. And then there are others who suggest that the commission should be abolished, believing the commission lost its utility when the guidelines became advisory. Today we will consider these different views on the guidelines and the commission. To facilitate this conversation, we are pleased to have with us Jessalyn McCurdy, this afternoon's moderator. Jessalyn is a senior legislative counsel handling criminal justice issues for the American Civil Liberties Union. She has also served as a counsel for the U.S. House of Representatives. She holds a BA in journalism from Rutgers University and a JD from Catholic University's Columbus School of Law. Please join me in welcoming Jessalyn and our distinguished panelists.
Thank you so much for coming out today. What a great crowd, standing room only. I apologize. There are reserved seats up here, and the reason why we've had to reserve these seats is because apparently the camera person will not be able to see the entire panel if people are sitting in these seats. But we're going to try to, I guess, get some more chairs if we can squeeze some more chairs in here. But I'm really, really glad to see everyone here, and I am just thrilled to have this distinguished, and everybody says distinguished panel, but this is a very distinguished panel today to talk about this very important issue around the federal sentencing guidelines. And I'll introduce the panel shortly, but I just wanted to give you a sense of kind of how this event came about. We're now 7 years post the U.S. v. Booker decision, which transformed the federal sentencing guidelines from a mandatory system to an advisory guideline system. On October 12th of 2011, the House Judiciary had a hearing entitled Uncertain Justice, the Status of Federal Sentencing and the U.S. Sentencing Commission 6 years after Booker, which began a discussion about the state of federal sentencing. During the hearing, the Sentencing Commission recommended several legislative proposals to Congress that the Commission feels would strengthen the current guideline system and promote the goals of the Sentencing Reform Act of 1984. Well, after the hearing, some advocates and practitioners were interested in hearing more about the Commission's proposals and having a more in-depth discussion about the pros and cons of the current advisory guideline system. And so that's why we're here today, to have that discussion. And we hope to continue this discussion about the state of the federal sentencing guidelines and hear from, again, our distinguished panel about the Commission's proposals and others on how to strengthen the system. But also, we would like to have a conversation about the relevancy now of the Commission. Now that we do have an advisory guideline system, some have suggested that maybe the Commission is not relevant anymore, but I hope we can have a discussion about that as well. So with that, I will turn to introducing the panelists, but let me just say how we're going to work this format today. I'll introduce the panelists. Each panelist will have about 5 minutes to kind of give us an overview of where they are on the Sentencing Commission guidelines, whether they think they should be advisory, mandatory, presumptive. Then I'll ask the panelists a few questions that I hope not only that any panelist is, I hope will respond to, and then we will reserve time at the end for questions from the audience. So thanks again. Let's start with Judge Patty Saris, who is the chair of the Sentencing Commission, and we are so glad to have her, that she's taken time out of her busy schedule to be with us today. Judge Saris is a district judge from the District of Massachusetts. President Obama nominated Judge Saris to be a member of the chair of the U.S. Sentencing Commission in April of 2010. The Senate confirmed her nomination in December of that year. Judge Saris has served as a United States District Judge for the District of Massachusetts since 1994. Prior to her appointment to the District Court, Judge Saris served as an Associate Justice for the Massachusetts Superior Court from 1989 to 1993. And from 1986 to 1989, Judge Saris served as a federal magistrate judge for the United States District Court of the District of Massachusetts. She received her BA magna cum laude from the Bradford College and her JD cum laude from Harvard Law School. Our next panelist, Professor Douglas Berman. Professor Berman attended Princeton University and Harvard Law School. After graduation from law school in 1993, Professor Berman served as a law clerk for Judge John O. Newman and then for Judge Guido
Calabrese.
Thank you. Both on the United States Court of Appeals and the Second Circuit. After clerking, Professor Berman was a litigation associate at the law firm of Paul Weiss, Rifkin, Wharton, and Garrison in New York City. Professor Berman's principal teaching and research focuses in the area of criminal law and criminal sentencing, though he also has teaching experience and practice experience in the fields of legislation and intellectual property. Mike Volkoff, partner Meyer Brown. Mike is a former federal prosecutor with almost 30 years experience in a variety of government positions in private practice. Mike served for more than 17 years as a federal prosecutor in the U.S. Attorney's Office in the District of Columbia, for 5 years as the Chief Crime and Terrorism Counsel for the Senate Judiciary Committee and Chief Crime, Terrorism, and Homeland Security Counsel for the Senate and House Judiciary Committees. And as a trial attorney in the Antitrust Division of the U.S. Department of Justice, Michael has extensive trial experience and has been the lead attorney in more than 75 jury trials, including some lasting more than 6 months. His clients have included corporations, officers, directors, and professionals in regulatory enforcement proceedings, internal investigations, and criminal and civil trials. He has handled a number of high-profile criminal cases involving a wide range of issues, including the FCPA and compliance matters, environmental crimes, and antitrust cartel investigations in countries all around the world. Welcome, Mike. And then last but not least, Amy Barron Evans. Amy is a sentencing resource counsel for the Federal Public and Community Defenders. She represents defenders' interests in sentencing policy matters, provides litigation support before the Supreme Court and courts of appeals, and teaches sentencing advocacy. She has authored numerous articles, papers, and briefs on federal sentencing and other criminal law issues. She is a cum laude graduate from Harvard Law and clerked for the Honorable Hugh H. Bounds of the First Circuit of Appeals. Amy worked as a staff attorney at the North Carolina Death Penalty Resource Center and was a partner at Dewey and Collier in Boston. Before joining the defenders, she was a co-chair of the Federal Sentencing Guidelines Committee of the National Association of Criminal Defense Lawyers and a co-chair of the Practitioners Advisory Group of the United States Commission. And that is our distinguished panel for the day. Can you please give them a hand? Okay, with that, we'll start with Judge Saris. Each panelist will have 5 minutes.
Thank you very much. So thank you for inviting me to speak about the relevancy and reach of the Sentencing Commission. As you might expect, I've given this topic considerable attention. Even after 17 years as a federal judge, my first year as chair of the Sentencing Commission has been quite an education. I believe that there are 3 major challenges in federal sentencing. First, over severity. Second, disparity. And third, recidivism. I want to discuss the Sentencing Commission's role with respect to each. And let me begin by emphasizing that the Commission is an independent, bipartisan agency located within the judicial branch. Wherever possible, we act by consensus. First, the Commission has been and will continue to be highly relevant in addressing issues of sentencing severity. One of the principal goals of the Sentencing Reform Act was to ensure that sentences were proportional to the severity of the crime. To promote that goal, the Commission took the lead on crack sentencing reform and the new mandatory minimum threshold levels, which lower sentences by an average of 25% for crack cocaine offenses, are consistent with the Commission's 2007 report to Congress. Last year, the Commission also voted to make the new guidelines retroactive, which will affect as many as 12,000 offenders who do not pose a threat to public safety. We have also just published a comprehensive report on mandatory minimum penalties. Nearly 40% of the current federal prison population was subject to a mandatory minimum penalty in sentencing. We concluded, let me make sure I keep catching the mic. We concluded unanimously in the report that certain mandatory minimum penalties apply too broadly, are excessively severe, and are applied inconsistently across the country. We therefore recommended that Congress eliminate or amend certain mandatory minimum penalty drug provisions. The Commission concluded that the stacking of mandatory minimum penalties for multiple offenses was often excessively severe. With stacking, for example, a defendant who was charged in the same indictment with multiple offenses involving a gun could receive a life sentence. This is even true for first-time offenders in cases that involve no physical harm or threat of physical harm. We also recommended expanding the safety valve. The Commission has also devoted considerable energy to the non-contact child pornography guidelines. And I want to tell you all that we are holding hearings on that topic in February. And finally, with respect to severity, the Commission is evaluating various reforms to the loss table in the guideline that is used for certain varieties of economic fraud, particularly focusing on securities fraud cases involving high losses. We have urged Congress to consider the impact of the severity of sentencing guidelines on the prison population. The Bureau of Prisons has reported that there is 37% overcrowding in the federal prisons. Second, let me address the issue of disparity. One of the principal goals of the SRA is to eliminate unwarranted disparities through the implementation of guidelines, but to permit the consideration of individual offender characteristics where warranted. Congress was worried about regional disparities as well as judge-to-judge disparities. I remember in the early 1980s when I worked with Senator Kennedy as a young staffer on the Senate Judiciary Committee on sentencing. Congress asked, why should a bank robber in Texas get a different sentence than a similar bank robber in California? After the landmark Booker opinion and the 7 Supreme Court cases that followed made the guidelines advisory, commentators have asked fair questions about whether the guidelines still eliminate unwarranted disparity. The answer is that they do. Over 80% of all sentences are within the guidelines or are subject to a government-sponsored departure or variance. In the remainder of the cases, the guidelines exert a strong gravitational pull on sentences, which is no surprise given that they represent the starting point for every federal sentence. To be sure, there's been a 5 percentage point increase in variances not sponsored by the government from 12 to 17%, but those variance rates have begun to plateau. The really tough questions that I was asked at a recent oversight hearing in the House Subcommittee involved regional disparities. 49% of judges in the Southern District of New York vary from the guidelines, while only 4% do in the Middle District of Georgia. Why, they asked. While this can be explained to some extent by differences in caseload or prosecutorial charging decisions and discretion, the sharp regional disparity is worrisome. We will be holding a hearing again in February, it's going to be a busy month, and issuing a report that explores these important post-Booker sentencing issues. The Commission continues to believe that a strong advisory guideline system best serves the purposes of sentencing. Recognizing that an advisory regime could be strengthened, the Commission unanimously suggested a set of legislative proposals to Congress that are firmly rooted in Supreme Court doctrine. First, Congress should require that appellate courts presume within guideline sentences to be reasonable. In Reeder versus United States, the Supreme Court held that, quote, if the sentence is within the guideline range, the appellate court may but is not required to apply a presumption of reasonableness. Second, Congress should require that the greater a sentencing judge's variance from a guideline, the more compelling should be that judge's justification for the variance. This came out of Ball versus United States, where the Supreme Court held, it is uncontroversial, to quote, that a major departure should be supported by a more significant justification than a minor one. Third, Congress should establish a heightened standard of review for non-government sponsored sentences outside the range that are based on sentencing judges' policy disagreements with the guidelines. As the Kimbrough Court put it, closer review may be in order when the sentencing judge varies from the guidelines based solely on the judge's view that the guideline range fails properly to reflect statutory considerations even in a mine run case. The Commission recommends that Congress require every sentencing judge to give the sentencing guidelines due respect. The Supreme Court has left ample room for Congress to do so. Quote, the fact that Section 3553A, the statute, explicitly directs sentencing courts to consider the guidelines supports the premise that district courts must begin their analysis with the guidelines and remain cognizant of them throughout the sentencing process. Further, in Kimbrough and again in Pepper, the court indicated that guidelines are due, at a minimum, respectful consideration under the existing statutory regime. Finally, Congress needs to resolve a fundamental statutory tension involving individual offender characteristics that has arisen as a result of the Booker case. The statute instructs the Commission to ensure that certain offender characteristics, for example, employment and family ties, are not ordinarily relevant, but another portion of the statute instructs sentencing courts to consider those same characteristics. Accordingly, judges often determine that guidelines have not sufficiently addressed offender characteristics and vary downward on that basis. Congress should either make clear that the Commission is not precluded from addressing certain offender characteristics that judges believe they are required to address, or Congress should make clear to judges that they are not ordinarily to impose a sentence based on those same characteristics. Another important way to address non-government sponsored variances is for the Commission to reevaluate guidelines with which stakeholders, particularly judges, have problems. I mentioned before the economic fraud and child pornography guidelines. They are examples of areas where increases in sentencing disparity have been signaled by increases in the rate of variances from the guidelines. This feedback loop is crucial to good sentencing policy. The final challenge I'll mention is prisoner reentry and recidivism. Much of the reform in this area has been bottom-up, judge-driven reform. Federal judges have been eager to employ drug courts, gang courts, reentry courts, and Congress has taken action with the Second Chance Act. Reentry and recidivism clearly fall within the Commission's statutory mandate. There's a paucity of data on the efficacy of existing reentry programs and of supervised release, and the Commission is very well situated to help bridge that empirical divide. We spent a huge amount of resources and staff time in evaluating the recidivism of crack offenders, which is about 30%. The Commission has also studied supervised release and reentry, concluding, among other things, that success rates in supervision are highly correlated with offenders' criminal history categories at the time of the original sentencing. I'm personally hoping that the Commission will make these issues a priority going forward. I'm looking forward to working with everyone in this room on this important and complex area. Thank you.
Thank you, Judge Saris. Professor Berman?
So thank you all for coming, and thanks for having me, ASC and ACLU. I first want to compliment Judge Saris because of the set of topics and issues, sorry, trying to get my notes up here, that she's outlined. Yes, I know. And I guess I just want to start with both based on the comments of Judge Saris and the other work that I know the Commission is in the midst of doing. To me, it's a no-brainer that the Commission remains incredibly important, incredibly relevant, incredibly essential to the development of a wise and just federal sentencing policy and really a broader, sensible approach, not just to federal criminal justice issues, but national criminal justice issues. I know it didn't ultimately get enacted, but the House passed and the Senate bogged down on Jim Webb's bill for a National Crime Commission. Given the fact that the House passed it, that to me is a sign that at least some members of Congress, if not all of them, believe it's important to be taking not just a broad view of federal sentencing law and practices, but of nationwide criminal justice law and practices, and it's something that the way in which Chair Saris has outlined her concerns and the Commission's concerns leads me to confidence that the Commission believes it's within their mandate and is going to be part of their work, maybe with a particular emphasis on federal offenses and federal offenders, but hopefully doing work that can inform the work of others. That's part of the reason why, as the Commission stands as not just a guide for federal sentencing law and policy, but also hopefully a profoundly valuable beacon for the work of state sentencing commissions and other policy reformers, I particularly want to urge at this particular moment in not just federal sentencing law and policy, but nationwide sentencing law and policy, that the Sentencing Commission shift its focus to stop worrying much, if at all, about unwarranted sentencing disparity and start worrying much, much more, although again I hear it from Judge Saris, so maybe they're already starting to worry about it, but I want them to worry even more about unwarranted sentencing severity. I think it probably was always wise for the Commission to worry more about undue severity than undue disparity, and I'll explain why in a minute, but particularly now, I think there is indications from all three branches of the federal system that severity is a much, much bigger problem and a much more enduring concern, undue, unwarranted severity, than is unwarranted disparity. Let's start with the executive branch. The Department of Justice, in its most recent letter to the Sentencing Commission, though mentioning an enduring concern about disparity, which is always the Department of Justice's reasonable prerogative to notice, though I'll mention in a minute, I think they're responsible for more disparity than the judges are. Nevertheless, in that letter, there was emphasis on the continued growth of the federal prison population. It is now, as of this morning, at 216,899, yet another record. Every week it sets a new record. That's despite the fact that federal prisoners have been released through crack retroactivity and a number of other mechanisms. And the Department of Justice recognizes not only is this an unsustainable pattern, given the size and scope and expense of federal prison availability, but also it ends up consuming a disproportionate and harmfully disproportionate amount of federal criminal justice expenditures and resources. The Justice Department has less money for case agents, for a variety of other purposes, or at least has less ability to ask for more money, because you can't wish away or cut the essential costs of a growing federal prison population and the healthcare costs and the related costs that go with that. But the letter from the Justice Department emphasizing this point is, to me, a sign that the executive branch recognizes that severity, as much if not more than disparity, is the pressing problem facing now the federal sentencing system. Let's turn to Congress. It certainly is easy to say, well, Congress always wants sentences to be more severe and never indicates that severity is a problem. However, if we look at their recent track record, that's a record that dates back to Booker, when Justice Breyer said the ball is now in Congress's court to respond to the advisory system as Congress sees fit. Tellingly, importantly, significantly, we've had the quietest period of increases in sentences in the modern post-Sentencing Reform Act era. There's been the least number of mandatory minimums. There's been the least number of changes. Now, that's partially a story of politics, but it's partially a story of Congress's recognition that the system is already plenty severe. And in fact, we had the most historically significant downward adjustment in sentences through the Fair Sentencing Act. So for all of the huffing and puffing that we hear from various members of the of Congress about those lenient judges, in fact, if you look at what they've actually done since Booker, it's clear that Congress is most concerned about unduly severe sentences, and certainly not radically concerned about increased disparity, because they've had precious little discussion of this issue, save for one recent hearing, and even that discussion was divided at best, and candidly, very few people showed up to it, so it was only persons who have a distinct interest in this topic, not a comprehensive set of concerns, obviously, in play. So I say the right way to read Congress's reaction to Booker is again to be concerned with undue severity, and of course, still in place, still controlling federal judges, is the requirement that they impose sentences that are sufficient, but not greater than necessary to achieve its purposes. Built into still applicable law that Congress has not changed is this idea of parsimoniousness, the idea that sentences that are too severe are worse than disparity, and in fact that is, I think, reflected in a variety of other things that appear in the Sentencing Reform Act. Patterns from the judiciary. Why are we getting more variances? Notably, we're getting a few more variances, but really not a lot upward. The vast majority of increased variances are downward. That is a statement in sentencing practice of judges saying they think sentences are too severe. We also hear this through judicial surveys the Commission has done about their own attitude. Notably, very few judges say we think the guidelines are too lenient in any respect, and they're not particularly concerned about the impact that that has, but often they articulate concerns about the guidelines being too severe, particularly for certain offenses and certain offenders, nonviolent drug and white-collar offenses, child porn. The judges are not merely saying they're too severe, they're saying they're much too severe, as evidenced by both their sentencing patterns and what they say. In addition, a judge has, among other things, out of my state of Ohio, surveyed jurors, and he's found that jurors think the guidelines are much too severe after they've heard all about the offense circumstances and not even heard any mitigating factors that come up at sentencing. So every, in my view, sort of source from the judiciary, not just the judges, but jurors as well, suggests that severity is a bigger problem than disparity. Last but not least, and this is the key point, even if disparity is a big concern, we're having disparity because of undue severity. The settings in which there are complaints about undue disparity increasing in the wake of Booker are high-loss, white-collar sentences, child porn sentences, and drug sentences, and it's because in those settings, everybody recognizes when they have individual defendants before them that the guidelines go too high, oftentimes crazy too high. And I think Amy will probably point to this data better than I can. When the Commission lowers its guidelines, specifically responding to the Fair Sentencing Act to lower the crack guidelines, we get less variance because judges are much more likely to follow guidelines that aren't unduly severe. And so the Commission is extraordinarily relevant, and if the Commission, in my view, wants to do excellent work on reducing disparity, it should do so by reducing unwarranted severity and start with the Justice Department, right? They're the ones not only who are complaining about the prison resource issues, but in particular, I think if brought into the right room and told that there will be no political hay made out of what they say, will do as good a job, if not a better job, articulating their view of when they think sentences are too severe and helping the Commission to bring the severity of the federal sentencing system more in line to what all of the branches, in my view, really think it ought to be.
Thank you, Professor Berman. One thing that I forgot to mention about Professor Berman, listed in his bio, is that the reason why he's here is he is the preeminent blogger on sentencing issues.
One of the reasons, I like to say that.
And many of us open up Professor Berman's blog right after we open up the Washington Post in the morning. So I want to thank him again for coming all the way from Ohio to be here. Mike?
Well, thank you. Thank you, ACLU. Thank you, ACS. I never thought I'd say those words. I am saying that. It's actually a pleasure to be here. Judge, it's great to meet you. I've heard tremendous things about you, and obviously your comments, I think, are very, very well taken. I'm going to be the bomb thrower. I get to be the bomb thrower.
That's why we invited him. He's the bomb thrower.
And let me start. The one fact that nobody's talking about, the political reality of what is really going on, is the crime rate is going down, folks. Every year, violent crime is going down. The reason why Sam Raymer and Bobby Vassar and Congress isn't busy is because the crime rate is going down. The reason why you don't have more mandatory minimums and you don't have more extensions of maximums is because the crime rate is going down. Now, what does that give us an opportunity to do? To do real bipartisan work, to do the real job. And let's not, stand up and, get talking points going about crime anecdotal evidence, because we used all those tactics. Here's an anecdote about what happens, and this is why we have to change the whole sentencing system. But there are things that we've got to call them like we see them. There is no way, and I love the commission. The commission, that is not the problem. The problem is Congress and the judges, okay? The judges more than anyone. And I'm taking off your judge hat. You're now the chairperson when I say that. But the judges more than anyone. Look, Judge Harold Green, one of my heroes from D.C., said to me when I was a prosecutor, "This is my kingdom, Mike. I don't give a damn what 3 yahoos say upstairs. I'm going to do what I want to do here." And that's the way judges think. They hated the guidelines when they were mandatory. And if I were a judge, I would have hated them. Because there are times when I think I know better. And that's the reality. So let's back up for a second. Well, sometimes they do. Depends on the judge. In any event, but let's back up for a second. There's no way we should get, I got my delivery yesterday of the Sentencing Commission's guidelines. It took a Mack truck to bring them into my office. That is ridiculous, okay? There is no way in a non-mandatory system that we should have 3 volumes of guidelines and sit there and calculate and calculate and calculate. And then the judge says, well, you know what, I've got 7 other ways to get around this, and I'm going to do it. And by the way, there's no appellate standard that's meaningful for what I'm going to do, all right? And everybody, and Congress is now going around saying, surprise, hey, we're getting more variances. Well, of course you are. So the first thing to me is, let's simplify the system, okay? Let's simplify it, and if we have to go to jury findings, I thought Matt Miner made a great point that if a jury can decide the aggravating factors in a death penalty case, they can certainly decide certain simplified sentencing factors. Let them decide. All right? That will take some of the discretion out of the way. And there's nothing wrong with that. Juries are smart, depending on the location. No, I mean, juries are smart, okay? And the point is that we need to simplify the system down to something that's basic, because I love that everybody wants to talk about how severe the system is. I'm sorry, politically, that is going nowhere, folks. It's going nowhere. You cannot do it that way. What you have to do in this time of downward push on the crime rates is look at certain issues, but try to get a bipartisan working group together of people who want to solve the problem. And it's hard to do that in today's atmosphere. I think it's irresponsible for the Republicans to come in and say, let's look at the budget of the Sentencing Commission. You know what? There are so many places you can look at for $17 million. The last place we need to start looking is the Sentencing Commission. The Sentencing Commission does its job. Congress is not in that sense. I have 2 other points. I do think that variances and departure rates are significant. I agree with the judge. I agree that geographic disparities of the magnitude that we're talking about are significant. I don't think 49 versus 40 versus 34 is enough to raise hackles, but I do believe 49% in the Sovereign District of New York, and we all know what's going on there. I mean, look, the prosecutors think they run the world, and the judges think they run the world. So they're going to, what a big surprise that 49% of the sentences given out in the Southern District of New York are below the guideline range. They know better. But what bothers me, and we haven't discussed yet, are the racial disparities. That bothers me more than anything. If the people are here and you supported the Fair Sentencing Act, okay, and we all, and I supported it. I thought it was outrageous to have a 100-to-1 ratio, and Bobby will back me up on this. I thought it should be 1-to-1. I still think it should be 1-to-1. But to have 20% of African Americans sentenced at higher rates than white Americans is just wrong. And that has to be addressed. To me, that's the more troubling trend than just the disparities within geographic areas. And I thought the Commission's research in March of 2010 was very, very important to look at. I frankly would have held a hearing on that issue alone, not going into the political sphere as we're talking about. So I would like to see a simplified sentencing guideline system. I don't want to get through books anymore. I don't want to cut down any more trees. I want it to be a 10-page book, 20-page book. And you know what's going to happen in that? You'll have broader ranges, okay? We're not going to spend a lot of time talking. We'll have a meaningful appellate standard, and judges will still have some discretion within that to do the right thing that they think, but we'll have a system that will finally be honest, because the system is dishonest now, and it was dishonest before, because everybody knew. When I went in there, you knew there were certain ways to get around the mandatory guidelines if you wanted to, and they're doing the same thing now with regard to the advisory system, just jumping through the particular groups. So I'm all about change, but I want to see change for the better. Thanks.
Thank you, Mike. Amy?
Well, I think the advisory guidelines system is the best possible system we could have. I assume we're going to have some time to talk about the simplified system
Yes.
and Judge Saris's proposal.
Yes,
too.
yes.
So I won't get into that right away.
Okay.
So I'll just tell you why I think the advisory guideline system is superior. Judge Saris pretty much said it all as a systemic matter. What I think is most important about the advisory guideline system is that the feedback loop is crucial. When Congress created the Sentencing Commission and the guidelines, it didn't subject the commission to other kinds of, to the sunshine laws that are applicable to other agencies that do things that are completely ridiculous compared to sending people to prison. Wasn't subject to judicial review. The rules of other agencies are subject, can be held unlawful and set aside if they're not explained, if they're arbitrary, if they don't comply with procedures. Other agencies cannot meet in private. They have to hold every meeting out in the public view. They can't have ex parte communications. None of this applied to the commission, which is pretty unbelievable given the gravity of their job. What Congress did provide for was the judicial feedback loop, and it was supposed to work through the departure standard. And what the departure standard said, which we've all long forgotten, it's worth remembering, was that the judge could depart if the judge found a circumstance that was not adequately taken into consideration by the Sentencing Commission. What happened to that standard? It got wiped out by the commission. The very first commission nullified that standard. And you know, I don't want to bore anybody with those details if you already know them, or you know, it's probably not the right time to talk about them. But what Congress had in mind when it wrote the statute, you know, there's two parts of this statute, 3553A and B. Who's a criminal defense lawyer in this room practicing or has been? Well, you know, I was and have been for a long time, and I consider
In Boston.
myself pretty diligent. I didn't even know about 3553A, but it's the first one in the statute. And it says, the judge shall impose a sentence that's sufficient but not greater than necessary to satisfy these four legitimate purposes of sentencing after considering all the relevant circumstances of the offense and the offender, the kinds of sentences available by statute, which are, you know, anything from probation to prison, not just prison all the time, and the guidelines and the need to avoid unwarranted disparities, which does not mean lockstep uniformity. But that statute was read out of existence because the commission adopted a departure standard that said, you cannot depart, basically, unless we say so, or unless the circumstance is atypical compared to what we say is the heartland. Of course, no one knew what the heartland was because the commission didn't explain the guidelines. It was really a terrible, disgusting situation. So what that meant, just to like sort of bring this to life, when judges tried to depart based on the unfair crack powder disparity, they weren't allowed because that was typical of all crack cases. I kid you not. every court of appeals held that, okay? And that was the commission's doing. So what Booker did, and we can't forget this, is dislodge that. Okay, it said 3553A is now the sentencing law, and we're going to excise 3553B, which basically permitted the commission to place those limits on departures and to not allow judges to depart based on mainly mitigating offender characteristics. The point is, in all of this, is that the feedback loop really never functioned before. It's working for the first time. And the commission, I mean, I think that the commission, people use the word relevant in different ways, but the commission has begun to be more relevant in sort of the real way on the merits. Do people respect the commission? Or do people hate the commission and try to circumvent the guidelines, like Mike said? Now, all right, people did circumvent the guidelines when they were mandatory, but it was really inconsistent and it was hidden. Now it's transparent. If the judge finds, that a different sentence complies better with 3553A, he or she openly imposes that sentence. Prosecutors are now allowed by the Attorney General to seek sentences outside the guideline range based on the purposes of sentencing and the relevant facts in the case. They used to only be able to move for cooperation and fast-track departures. So what they would do is hide their disagreements with the guidelines in the cooperation and fast-track departures. So we have a more transparent system. I would like to say, we've seen this in action, and what happened with crack is actually an example of Booker in action. I think that a lot of, the commission is to be greatly commended for starting the campaign against crack in 1995. But Booker gave it a huge boost forward. And that's because the commission was worried about the variances from the crack guidelines based on judicial disagreements. So, I mean, it's in their report, in the 2007 report. We're going to reduce the guidelines by 2, which they had never before had the courage to do, since 1995. And Congress, you really need to do something quickly, because judges are varying from the guideline range based on their own disagreement with the ratio. And the commission was also very worried that the Supreme Court, I don't know if worried is the word, but they saw the writing on the wall that the Supreme Court was going to do what it did in Kimbrough. And even Senators Kennedy, Hatch, and Feinstein wrote an amicus brief to the Supreme Court saying judges should be able to disagree with unsound guidelines such as the crack guideline. So I have quite a bit to say about, at any rate, I think that both the Commission's proposals and Mike's proposal are very wrong-headed, because they would, Mike's proposal would completely eliminate the judicial feedback loop, eliminate it. And we could talk about that later. And the Commission's proposals would stifle judicial feedback, and I don't agree with Judge Saris that they are rooted in Supreme Court law, and actually think they're inconsistent with Supreme Court law. So what I really would, wish for from the Commission going forward is to really tell Congress the truth and the full story about how the advisory guidelines system is working. Not to give, sound bites about racial disparity, and I'll talk more about racial disparity maybe later in the panel. But, I'll say this now, one complaint I do not hear from defenders who represent racial minorities, most racial minorities in federal court, is that judges discriminate against their clients. That is not happening. Reality check, everyone, okay? And I'll give you some statistics to show how judges have reduced racial disparity built into the rules. So I think it would be helpful, more healthy, for everyone if the commission would give, maybe the next time it issues a report or is before Congress, to give a more balanced picture of how the system is actually working. So.
That's actually a good way to transition into a few questions, and then we'll open it up to the audience. You left off on this issue of whether or not the Commission's proposals are constitutional. And so I would like to give both you, Judge Saris, and anyone else on the panel an opportunity to talk about either why you think the proposals, and I guess particularly the proposal around giving the guidelines substantial weight, and even the proposal around strengthening the appellate review standard, why you think they would hold up to constitutional scrutiny, or why you think they would not. Let's start with Judge Saris.
Well, let me just start off with our basic point, which is that we think that a strong and effective advisory guideline system best serves the purposes of sentencing. And as we all know, since Booker, there have literally been 8 Supreme Court cases with a lot of language in them about what was and wasn't constitutional. So when we look back at those 8 opinions, what we decided to do is propose a set of reforms that would, or adjustments, so you've got proposals, that would essentially bring the statute in line with what the Supreme Court had been saying, and also to make sure that the advisory system remained strong and effective. We literally took language almost right out of the Supreme Court opinions. We went to Rita, we went to Gall, we went to Kimbrough. We came as possibly plagiarizing the opinions by making the proposals. And in fact, I think at this point we're proposing even on a substantial weight, where we think a better way of wording it might be due respect, because that comes even closer to what the Supreme Court has actually said. And that's why I went in my little speech, I mean, it was almost probably pedantic, but I literally quoted from the Supreme Court cases where we got the language from. So we think it's fully constitutional, and we think it's important to make sure that the statute reflects what the Supreme Court has been saying, and what we think, particularly with a national appellate review standard, will promote just a stronger
Can I
system.
play devil's advocate for a second? If we know what the law is, why does Congress need to amend it?
Right.
If the standard is the same that we're going to legislate, to me, it seems to me you have a conflict right now in appellate standards, right, in terms of the analysis that's going on among the appellate courts. That's a prime example for somebody, and particularly Congress, to get involved. If you want to make the system a presumption system, and we looked at this when I was in the House Judiciary, we looked at this and we thought about it. It is, I mean, it's sort of tempting the Supreme Court. It's like, hey, Scalia, we got something to tempt you with. Are you going to smack us on the nose or not? I think that in the end, I do believe that given the mess and that Breyer is going to be on your side, I think that in the end it will probably pass. But the question is, okay, you have it. Now what? What have we accomplished? The problem is the Commission is being asked to do things with both of their hands tied behind the back. You don't have an appellate standard. You don't have a standard for what the guidelines mean. So let's fix this. It's not fair to the Commission. I think it's unfair to even have the title of this be, what is the Commission's role? I'm sorry. What is Congress and the judge's role? The Commission is doing its job the best that it can given the Supreme Court decisions, and I think it would pass. But I still say it's, look, this is a great proposal. I think you have to make it politically. You have to come up to the Hill and say, here's how we can fix it. But it's up to a more honest, robust dialogue to fix this issue. And navigating some very difficult issues created by Booker and Blakely.
And I'll return to my themes. The way you make sure the guidelines get due respect is to make them respectable. And the areas where they're not getting due respect, high-loss white-collar cases and certain drug crimes, still, in fact, I'm disappointed they're getting as much respect in the crack arena when we're in an 18-to-1 compromise that's at best a compromise, at worst just a watered-down version of the racial dynamics that led to 101 to begin with. But noticeably, their guidelines are getting more respect. I'll tell my kids as much as I want, give me more respect, but unless and until I do something that earns their respect, whether it's my kids or my students, I don't deserve it. And so to me, tweaking any of this stuff, not only because I agree with Mike that if it's just a codification of what the Supreme Court has done, I don't see what it achieved, in addition, and again, this is where it doesn't address the problem. The problem with appellate review is not a presumption of reasonableness versus non-reasonableness. It's that what reasonableness is makes no sense against the backdrop of a bunch of guidelines, again, the ones that we're most familiar with that are the source of the most controversy, that aren't themselves reasonable, and that the commission itself has admitted sometimes between the lines, sometimes with in black and white, are not reasonable guidelines. And if the commission were just to come out and say, we need to earn the respect, and Congress let us by reducing these sentences, and the way I would approach simplifying it, it's very simple. Just go through and eliminate 30% of the most problematic enhancements, right? I don't even have to say enhancements. Eliminate 30% of the guidelines. That will reduce severity, because 99 out of every 100 provisions in the guidelines increases sentences. So we'll simplify by just eliminating that stuff and trust the judges. And I don't think they're doing it based on their own parochial, this is my fiefdom. Judges know more loss actually created to real human beings should lead to a longer sentence, but they don't need a slide rule, or, I mean, you guys are trying in your latest amendment. Here are 4 different ways we think we can calculate loss. My head hurts, and the judges' heads hurt too, and they're not going to do it. That will earn respect. All that will do is earn the kind of subterfuge that even in an advisory system, judges have to engage in, because we've still held the guidelines up as this kind of patron saint of first principles, when sometimes they deserve that because they're well written, but other times not at all.
Can I give Amy
all right.
a chance to respond, then I'll
All
get back to you, Judge.
You want me to just jump in?
Well, I would just say that, substantial weight is not a no-brainer. It's, no, it wouldn't make it past the Supreme Court. Only, there's one justice who says the guidelines can be given some significant weight, and that's Alito. And all the rest of them have said no. No. So, I don't know where, I think, it will be very disruptive and too bad if we have to have another several years of litigation around this stuff. The court has said over and over that the guidelines are just one factor. There's no legal presumption. They're not only not mandatory, they can't be presumed reasonable. They're not entitled. Policy statements, which are actually the biggest culprit in the manual, are not entitled to weight. But the commission's 3-step procedure, which is, under the commission's 3-step procedure, which the commission also says the purpose of that is to make sure that the guidelines are given substantial weight. Under the 2nd step, judges would be required to consider all of the restrictions on non-guideline sentences. That's like back to 3553B. And a lot of the policy statements actually quote from and cite 3553B. So it's just, it's like what they said in Spears, it's a smuggled in dish that is indigestible. Really. And as far as Mike,
As far as Mike, I don't like
Mike,
the way that
the
started.
appellate
As far as
review,
Mike, let's,
the appellate review trashing. Actually, I really study appellate review really hard. Like, I read all the cases.
And I trust you.
And well, you probably don't, but substantive reasonableness works the way it's supposed to. Appellate courts are not supposed to be substituting their judgments for the district court judge. What the appellate courts do a lot is use procedural reasonableness to reverse sentences that are not adequately explained, or when the judge treats the guidelines as mandatory or doesn't consider adequately the parties' arguments, or whatever. Those sentences, you can get a sentence reversed for procedural unreasonableness in a heartbeat if it's truly procedurally unreasonable. Appellate courts are not supposed to be enforcing the guidelines. That's not what they're supposed to be doing. So, and there's also this common wisdom, a lot of folk wisdom floating around out there with no proof that when judges do reverse for procedural unreasonableness, the same sentence is just imposed on remand. Wrong. A different sentence is imposed more than half the time because the judge is now thinking about it. Okay, I need to think about this a little more carefully, and more than half the time it results in a different sentence without the appellate court being overbearing, which is unconstitutional. And as far as closer, well, are we on to the closer review? In Kimbrough, the court dismissed the idea of closer review. It didn't say we're adopting closer review. Justice Breyer brought up closer review as a possibility during oral argument in Gall. I was there. Justice Ginsburg cites it in Kimbrough oral argument transcript. I'm sure that he got her to discuss it in the opinion. And the idea, he said, we should adopt closer review because the commission has the capacity to base its guidelines on empirical data and national experience. She says, okay, well, closer review might apply, but there's no occasion to talk about that here because the crack guidelines were not developed in that manner. The court has not even gone close to whether that would be constitutional. Justice Scalia in concurrence said, no way is that constitutional. The court rejected in Spears the idea of closer review again. And in Pepper, Justice Breyer in his concurrence asked them again to adopt closer review, and they completely ignored him. Remember, this is a pretty important concept in the advisory guidelines system, and that is that the difference between advisory guidelines and either presumptive or mandatory guidelines and what makes the advisory guidelines constitutional is that judges can disagree with a guideline based on the purposes of sentencing and not just facts. The court held that in Cunningham versus California and has, went on and said it in Rita and then in Kimbrough. If you want to know Justice Kagan's position when she was Solicitor General, she said the very essence of an advisory guideline is that a judge may disagree with it as a matter of policy. So this is a risky business if the commission is serious about, I guess I just don't know where it's coming from, especially when the variance rates are so incredibly low, 17%, when the guidelines don't even contain any mitigating factors. It's outrageous that it's not 80%. I mean, come on. Nobody has mitigating factors in their case. So, I think that, I appreciate the fact that the commission is trying not to do something radical. But, again, I would urge the commission to maybe sell Congress on the idea that the system is working pretty well. It's narrow ranges. Judges are when they do vary, they vary. The median reduction is 12 months. I mean, what is all the hype about? This all seems like a drastic waste of time.
Judge Saris, would you like to respond?
Whew, all right.
You have 2 minutes.
Yeah, right. In 30 seconds.
Let me just start off by saying I couldn't agree more with Professor Berman that we have to make sure that our guidelines earn the due respect, which is the term that we are proposing for the weight to be given to the guidelines. And when I started off, it was a whirlwind year. I mean, I've been a sentencing judge, as I mentioned, 17 years on the federal side and 5 years on the state side. And I had absolutely no idea when I came to the Sentencing Commission how much work went into every guideline. The vast variety of guidelines. Last time around, it wasn't just about crack. It was also about straw purchasing of firearms. And to that guideline came a huge amount of data. How many were going across the border? How many were being sold to prohibited persons? And also, what were the reasons why judges were varying? Was it the girlfriend was buying the gun and they didn't for no money, and so therefore you should have a mitigation departure? I mean, we basically used what others have called our institutional strength to go code into our cases, come up with guidelines, and empirically come up with a fair range. Similarly, this time around, we're going into the economic loss tables. What are people doing in securities fraud cases? How do you compare gains and losses? What other guidelines might it affect, like money laundering, tax, whatever? I mean, we are going into it. Maybe they are complicated. I think that's a fair concern. But the respect is only earned to the extent that we rely on our data, we rely on our hearings, and we rely on the basically the input of every one of the stakeholders in this room. So yes, we do need to earn respect, and I think it's hopeless with your teenagers, but maybe the sentencing can go there. But let me just say, with respect to the, do you need it? I mean, to some extent, the reason I feel so confident that it is constitutional is because, I mean, we just sort of fought through, like, coming as close as we could to what the Supreme Court said. So then the question is, all right, well, why you need to do it? The Supreme Court said it, fair enough. Except for what we're hearing in our hearings is that appellate courts are saying that the appellate standards are unclear, and it is uncertain about what they're supposed to be doing. And there is an absolute circuit split on whether or not what the appellate standard should be. And there are certain things that should be done to strengthen the guidelines. The three-step process, I'm actually a little surprised is pushed back on, so since basically every circuit except one follows the three-part process, and it's been in the guidelines basically, as far as I know, without criticism for years. So I think that the real issue going forward is that when we do our guidelines, we need to follow the feedback loop. We need to make sure that judges are taking the guidelines seriously, and we earn that respect. And as far as, I mean, no one's coming back to the issue of severity, but I also have to underscore that to the extent that for example, mandatory minimums are too severe, the guidelines are pegged to those, and that's by statute. So we have to make sure we're not just addressing the disparity issue. I don't want to get lost, but we're all sort of agreeing on is that some of these amendments are just too severe.
So I guess that's a good way to transition into this issue of disparity. Professor Berman says let's not focus, the commission shouldn't focus so much on disparity and should focus on severity. Mike brings up the issue that we should be outraged about these racial disparities that have came up through the Sentencing Commission's 2010 report, which, among other things, concluded that under an advisory guideline system, black males receive longer sentences than white males. And this has led some to conclude that the advisory guidelines have resulted in more racial disparities in sentencing. But there has been another study that has concluded differently, or almost oppositely, if that's a word, than the Sentencing Commission's 2010 study. Has looked at the same data. Amy, was it the same data? Penn State study, and has concluded that they did not come to that conclusion that black males are receiving longer sentences. How would anybody on the panel address the studies, the validity of the studies, whether the conclusions of the studies should lead us to believe that an advisory guideline system is creating more racial disparities, which is exactly what it was.
Can I just say one thing, and then I'll turn it over to the judge, because I think she needs to. But I have found in general, and I've been obviously involved with the Sentencing Commission on Capitol Hill and whatnot, I have found that their work is, let's talk about a presumption of correctness in terms of they're clear about their methodology, they are very thorough. I mean, their value in collecting data and analyzing data is phenomenal. So to me, questioning whether or not the commission study is somehow going to be offset by Penn State and a Penn State study which says to the contrary, all I'm saying is we've got a prima facie case here of a problem. And maybe the commission has to do more research, but frankly, Congress needs to do something in this and look at the issue, because this, to me, was the purpose of the Sentencing Reform Act. This was the major purpose of the Sentencing Reform Act. And, you know, severity, schmerity, whatever, we can get to that, but this is a more serious issue. And I think it is, I think we should work with the commission's report, and we should go from there. We don't need about 20 more studies, folks. We need the commission to follow up, and for Congress to do its job.
I don't think we need 20 more studies, but we need one good study of the impact of prosecutorial discretion. And there actually is a new study out from some folks at Michigan that documents from their statistical methods, and I won't do the comparative Big Ten schools between a Penn State study and a Michigan study, but I will emphasize the point that whatever else we think about the impact of judicial discretion, whether it was back in the mandatory pre-Booker system or the advisory post-Booker system, everything that judges do at sentencing is in open court, is transparent, is subject to full adversarial procedures, and is subject to appellate review. In contrast, every decision that prosecutors make is largely the antithesis of transparent. It's hard to even know who's in charge in the prosecutor's office to decide what the charge is going to be, whether it's going to include a mandatory minimum, what they think the distinction between possession of child pornography, which is a 0 to 10 range, or receipt of child pornography, which is a 5 to 20 range. Even knowing who makes that decision, let alone having any basis to think that decision is being made the same way from Georgia to New York, that being the two geographical. And if we want to highlight geographical disparity, go through, let's say, do we want to do fast track? Do we want to do substantial assistance? Do we want to do safety valve? You name it. Even the third point for acceptance of responsibility. The one thing we know for sure, we don't know if it's racial, but we do know there are incredible disparities, neither explained nor subject to any review in how prosecutors administer the tools that get you out from not just advisory guidelines, but mandatory minimums. And in fact, the couple times, and it's only been a couple times, the commission has ever tried to do a systematic study of prosecutorial discretion. There's a 1991, I think it is, report on, or maybe it's 99, on substantial assistance, and that came out with the conclusion that legitimate variables that should affect what a discount you get for substantial assistance, this is all pre-Booker, had no explanatory force for differences in lengths of reductions, and all of the illegitimate factors, race, socioeconomic class, and a variety of other pernicious, what we think the Sentencing Reform Act was for, were the best explanatory basis for understanding why some defendants got huge credit for substantial assistance and others didn't. That report got no attention from Congress, and Congress, understandably, because prosecutors have more juice than anybody else, certainly more than the judges do, has never really looked into the impact of prosecutorial discretion. Notwithstanding that, when the prosecutors want more lenient sentences, they invent something like fast track. And Congress had to, and Mike, I think, deserves some credit for this, at least put some regularity to that, without which the disparities would have run even more amok and continue to have both geographical biases and a lack of transparency and consistency that prevents us from even knowing what's going on, let alone having data to compare to see whether it's race or gender or other kinds of factors that are leading to those disparities. And so to beat up on judges at any point in this process when they're subject to so much more scrutiny and so much more attention, oh, and by the way, have been appointed by a president and confirmed by a Senate, seems to me just so missing the piece of the problem that we know endures and yet escapes the serious scrutiny that it deserves if racial disparity and disparity more generally is truly our concern.
Judge Saris and then Amy. Judge
Yes,
Smith.
I'm just going to sort of say what we found. So in 2010, we issued a report, a multivariate analysis, following certain statistical methodology, which we then had peer reviewed by various, I think 2 to 3 anonymous reviewers and various well-known people who are statisticians. So we followed a process to get to it. And we found, not me, I'm not a statistician, but our statistical arm, which is terrific, found that the average sentence for a black male was 20% longer than that for a white male in the post-Gaul period. And I think what's important to add there is no one here is accusing judges of being racist. Nobody. I think what we are going to be studying this more in the in our Booker hearing and report. What our preliminary data is showing is not that the black male sentences are going up, it's that white male sentences are going down. And what we think is happening is that we can't control for a lot of what the individual offender characteristics are, notably employment, or somebody's employment status somehow benefits certain people more than others. There are other issues like family ties and the like, or particular criminal history violence and that you can't pick up. And so we actually have not got data on exactly why there is this difference. Penn State did an interesting study to try and deal with the same numbers. And there were very different methodological approaches and some disagreements. And so what I just wanted to point out there is that even under that model, under the Ulmer model, there are statistically significant differences between black and white males. Women always get lighter sentence. So I'm talking at this point about males. And there are certain differences that you could have a disagreement over, or, you know, how you deal with immigration cases or alternative sentencing. But my bottom line is that there were differences in the sentences under both studies. It doesn't by any means impugn the integrity of judges. Judges, let me just sort of be a Pollyanna for a minute. We've got the best judiciary in the world. It's an independent judiciary, as Professor Berman said. It's named by the president, it's confirmed by the Senate. They're doing the best that they can, and let me tell you, it is the toughest part of being a judge. Judges always learn that in baby judge school, and it is in fact the case. So no one is saying that, but it is something that I think as a commission we are watching because it's of concern. That's just
Okay.
Yeah, we'll actually, we started late, so we're probably gonna add a few minutes on the back.
Okay.
Just a few, though.
Did I touch
No,
Okay,
we
the
started.
Penn State study was peer-reviewed too, and the reason, I'll explain the differences in them if I can. I'll try to do it in not too boring a way. But the problem with both studies, and all of these studies, is what Judge Saris mentions. The commission doesn't collect, you know, these studies all use the commission's data set. The commission doesn't collect and therefore can't measure the effect of lots of variables that legitimately affect sentences. Okay, that's the major problem with these studies. The difference between the commission study and Congress needs to understand that too. I mean, the commission has included lengthy warnings about that issue in its reports, but it didn't include that warning in its last submission to Congress, and I think that's very dangerous. Anyway, so in the commission has also previously been very careful to say, okay, we can't measure these variables. You know, there's a whole list of variables that aren't included in the study, like any mitigating or aggravating factor that isn't in the guidelines. Violence in criminal history that isn't taken into account in the guidelines. It's an unfortunate fact of life that black men have more violence in their criminal history, at least recorded, than white men, okay? And judges, you know, legitimately when they're asked, okay, the defense lawyer says, I want probation for this guy, and the judge looks at the pre-sentence report and he's like, but no, I can't do it. You know, I can't do it because he has this record of violence, which it doesn't make any difference in the criminal history score. I won't get too technical, okay? Okay, the second issue is that these, the results fluctuate from year to year. The commission's been doing these studies for years and years, or has done several of them. And some years there's no statistically significant difference. And then the next year there is. Or one year there's a statistically significant difference in drug cases, but not in non-drug cases. And then the next year it flips. So what the commission has said before is fluctuations of this type indicate that they don't support the idea that judges act on stereotypes and bias. Okay? The latest study masks those fluctuations by aggregating years and not doing any separate analysis of offense types.
And if I could just throw in, there's a very important bit of statistical noise here that should not be lost, not only because it's a huge political problem, but it's something that I will instantly discount the results of the survey of the data unless it pulls child porn cases out of the data set, because the latest statistics show there's 2,000 child porn cases and about 1,200 of them have below guideline sentences, and they're all white defendants.
Yep.
And so I think the easiest explanation for that entire 20%, or if not the entire 20%, at least a big part of that is, in fact, white child porn downloaders are getting significant leniency, right? But I don't think unjustified leniency, because the guidelines suggest that for downloading the wrong pictures on their computer, they should get 20 years. And so a judge gives 5 years. Well, that is coded as a massive reduction relative to the guideline range, but it is really not a reflection either of, well, if that was a black guy downloading that, I would have given 20. It's the result of those guidelines being that way and the failure of judges to believe that folks who merely downloaded the wrong dirty pictures, when there is a psychologist report or some other indication that they're at low risk to recidivate, think that it's necessary to send somebody in prison for that long. That's another factor, and this is my own personal experience, different in kind as a hired expert sometimes in these cases. I'm still waiting to be hired by a minority defendant. They don't have the resources to devote to doing the kind of sentencing advocacy.
For free, Doug.
I do it for free a lot of the time, but notably the folks who are working for the folks who are free don't have as much time to call me up and corral me in, right? And so, again, that's itself another variable that I think plays a profound role in the way in which racial disparity, structural disparity, finds expression. And so I'd be suspicious if something says, no, all the things come out the same because there are so many factors, but I don't think it's judges having discretion. It's a cumulative set of discretionary actors that reflect the kind of structural problems that our criminal justice system reflects beyond federal sentencing profoundly.
I also think it's hugely dangerous to focus on this issue. Judges, there were some studies before the guidelines went into effect that purported to show that judges discriminated against racial minorities. Those were re-examined a couple years after the guidelines and mandatory minimums were in effect and found to have been inaccurate. Okay, but it's too late by then. So now we have, this new mandatory guidelines and mandatory minimums system, which, the guidelines are fine as long as they're advisory and as long as the commission starts paying attention to fixing them. But the second those rules went into effect, I wish I had my chart here and some of you have seen it, but here's the line for white defendants and Hispanic defendants and black defendants goes like this, immediately. Okay, so that's a brand new kind of racial disparity that opens up because of the rules, okay? And some of those rules are not necessary to advance the purposes of sentencing, which means that is unwarranted racial disparity, and those rules are notably the crack guidelines and also the career offender guideline.
And Amy,
So I want to tell you just some data about that judges have saved in crack and career offender cases. And then I
in
will
30 seconds.
stop.
Okay.
Okay. Since 2006, when we did this little study, 2006 through 2010, by imposing below guideline sentences that they couldn't have imposed under the mandatory guidelines, and we figured this out by comparing it to 2003, judges have, through downward variances, saved 3,500 African American people 14,000 years of unnecessary incarceration under guidelines that the commission has found are unjust, okay, crack and career offender, and nearly 900 defendants of other races saved over 3,000 years of unnecessary incarceration under those same guidelines. So, I mean, to focus on these unreliable type studies that everybody knows are, you can change them just by changing some little bit of the methodology and you get a new result the next time you try it. It's wrong because it takes attention away from much more problematic kinds of racial disparity that have been alleviated by judges during the advisory guidelines era and that need the attention of the commission and of the Department of Justice, instead of casting aspersions on judges who are, like Doug says, making their decisions in open court.
Okay. And with that, we will open it up to audience questions. Bobby Vassar.
From a policy perspective, and from a policy perspective, and perhaps from a perspective as a black male, I'm, I have to tell you, suspicious of the source of anyone proclaiming discrimination against black males when I look at the proposed solutions to that discrimination. And the first one that I saw was the suggestion that we need to ensure a uniformly severe sentence for all in order to eliminate the purported disparity against black males. So you want me to have zero chance of making an argument for a lower sentence so that I'm relieved of the possibility of someone else getting a lower sentence than me. I'm a little suspicious of your motives in proclaiming racial discrimination against me in those settings, and so I'm concerned with the suggestions that there is discrimination against black males without more information as to how that comes about. And I'd like to have a discussion about what the remedy is to that problem if it doesn't exist.
I think you raise a great point, Tommy, which is what are the causes of the change, if the disparity. If the disparity is because, as Doug was suggesting, the great variances that are given out in child pornography cases, obviously, that's not a justifiable basis to get concerned about this. What my concern is that if the commission finds, or if the data shows that there are similarly situated and similarly situated in, as close as you can get to in these circumstances, situations where that does occur, where you do find race as an explanation for a difference, that is of major concern to me. Not of, a bunch of whites are getting a more lenient sentence. I don't care about that. I care about making sure the system itself works in the right way. To me, if you were supporting the crack powder issue, you should be saying, let's look at this issue. I'm not saying it's resolved, but if you were worried about the crack powder issue and the racial disparities, you should be worried just like this. You can't speak out of both sides of your mouth. You have to sit there and say, let's find out the reason. We knew why crack powder, there was a reason. It was in the law, okay? And we knew what the reason was. But here, we don't know the reason yet, and I'm saying that's the first thing. Even aside from that, look, I'm surprised that you, Sam Raymer, and others aren't looking at the issue of simplifying this ridiculous system. You've got a non-appellate standard. You've got a ridiculous, what the hell does substantive reasonableness mean? I mean, lawyers, we got a great monopoly. We create a statute, fit the word in reasonable, and then go sell our services.
Guess what? That's the statute Congress.
Wait. But what I am saying is that we are not doing our job. And I'm saying there's a better way to do it. Of course, Amy's going to sit here and say, hey, this is all great, folks. All our federal public defenders love it. We go in, we tell the judge, we put on a sob story, and the judge is going to buy it. They're going to do what they want to do. Okay? Let's be honest, except if it's my client in for a white-collar fraud case, he or she's going to jail forever. Okay? But what I'm saying is that, look, the racial issue, we shouldn't get off on whether or not judges are racist or prosecutors are racist and everybody's racist. We've got a problem, and we need to find out why. Then, we've got a bigger problem, folks. We can sit here and talk about and pull out data and do all this stuff. You've got a system that's broken. It's not working. We can sit here and say, go look over here, and it's good over here. Look over here, let's divert a little attention. You have a system with no statutes in place. Okay? Some of the best work that gets done by Congress is when people legitimately come to the table and work to solve a problem. And Congress is being irresponsible. Okay? And I will blame judges, because I've been in there. It's called rovitis, folks. It's called rovitis. I remember I was with one of the judges who came from the Antitrust Division, and I was here in D.C., and I went in the back. He and I worked together in the Antitrust Division. He said, Mike Rudin, Judge Rudin. He was great.
Yeah.
And here's what he said.
Oh, we're not doing policy by anecdote.
No, this is what he did. I come in, I said, Judge, it's great to see you. He goes, I am so bored. These stupid drug cases. And before he talked to me, he took off his robe, crumpled it up, and threw it into the corner. And I said, Judge, I couldn't have said it any better, okay? Because, I'm sorry, judges, Harold Green, one of the greatest judges of all time, did dispense justice. I never could argue with him. because he was right. And he knew he was right. And he held the guidelines unconstitutional. In any event, I think that we have to be honest about what's going on here. Judges are very, when the judges don't have to do it, they're going to do what they want to do, folks. What a surprise. You turn it into an advisory system and we have a greater rate of variance. What a surprise.
Next
Why
question.
is that wrong? That's what I would like to know.
What
They
I-
are judges.
In that spirit, I'd like to know, since Justice Breyer at the end of the Booker decision said, Congress, the ball is now in your court, which kind of suggests that this is not the perfect system from the judge's perspective, at least from Justice Breyer's position. I'd like to ask first, Judge Saris, why do you think an advisory system is better than a mandatory guideline system?
Can you say who you are?
I'm Sam Raymer. I'm the guy that Mike Goldhuff's been referring to.
So we should be meeting with Bobby Vassar right now.
This is our meeting.
In the Commission's view, in my view, the advisory system is a better system than a mandatory system because it both is a starting and an anchor point for the judges so that it sort of irons out, everyone's starting at a different place, but it gives you enough flexibility to adjust the individual circumstances of the offense or the offender that aren't taken into account by the guidelines. So it essentially creates a more just system because you start with a certain point. Most people are following that initial spot, but you can adjust if there's an appropriate basis for doing so. A mandatory system, a mandatory guideline system, as I understand the way it's being proposed here and in other proposals, essentially a judge does not have any discretion, I think, to part or vary if there's an individual circumstance or the offense doesn't quite fit into the heartland. So we want to strengthen the system. We want to make somebody explain in detail why they varied. We want somebody to have a meaningful appellate review standard. We don't want it to be pure discretion. But as I understand the mandatory system, the way it's being proposed, once a jury found a fact beyond a reasonable doubt, say, there would be no basis for doing anything other than what that sentence is. And that's why in our mandatory minimum report we keep repeating, and I know mandatory minimums are different than a mandatory sentence, but the same set of issues. One size doesn't fit all. And sometimes Congress thinks about the world's worst offender when they're setting a mandatory minimum. They're thinking about the big bad guy that we all agree, gee, just send that person away. But there are often, for every horrible you can tell me about, I can think of a situation which is far less severe. And so I think that's in general why we think, and we go back to the guideline system, is the best way that you can go for a just system that eliminates unwarranted disparity but gives a little bit of flexibility when it's called for.
Can I say, with regard to, I think it, Judge, I think you raise a good point, but I think it really, you can't just say mandatory system without saying, well, what's the mandatory range? And, okay, it could be a very broad range. One of the ideas Ron Weiss and I sat down with and talked about for a long period of time was a very simplified system, which is larger areas of mandatory sentencing, but you can also build in, I mean, who's to say that it has to be exactly like the Commission or like the Sentencing Reform Act had? Why can't we have specific factors that are looked at for taking the situation out of a sentencing case where the range doesn't accurately reflect that, where you want to, there is a legitimate reason for going out of there. What I don't think is having a term reasonable as an appellate standard and no meaningful, sort of guidance in this area, like you're saying. Breyer basically expected Congress, and of course he did, because he worked on this probably with you when he was Kennedy's chief of staff on the Senate Judicial Committee.
Jim Flug, I got to out him right
Yeah.
here. From Kennedy's staff back in the day.
Right, and so all of you, Senator Kennedy was the leader of this, as I recall, and what I'm saying is, there's a way to do this where you can preserve guideline ranges and they don't have to be overly severe and everybody's trying to get around them, but make the system honest and make it work. Right now you've got dishonesty and you've got appellate courts saying it's dishonest.
Can I say one thing? 3553A is a statute which guides judicial discretion quite intricately. And judges stick very close to the guideline range under it. The reasonableness standard of review that the court adopted in Booker was enacted by Congress in 1987. So, I mean, you know, Mike, the idea that things are craziness. What was crazy that we had a statute was that we had a statute that no one even knew about, right? 3553A was just like, oh, that's interesting. What's this doing here? No one even knew what it was.
And for the record, I believe the framers liked the unreasonableness standard pretty darn well when they wrote it into the Fourth Amendment. Now, it's taken us a while to come up with standards, and again, what's great, I think, about the way the common law of the Fourth Amendment evolved is that Congress is not sufficiently content with that, they can pass statutes. So if Congress, and this is again, the ball is in Congress's court, and it's interesting to see what they've done with the ball. They've left it there because they're fine with how the game is being played.
They are not. They can't pick it up. That's the problem. They can't pick the ball up, and the reason that they won't, and nobody's going to do anything, is because the crime rate is going down. Nobody's going to make their...
Although the irony here, Mike, I want to pick up on that point.
Political points. Nobody's going to make their political points. There's not going to be anecdotal stories, and everybody's going to say, we're tough on crime. That's not...
Although, again, the things that really matter, the things of the Commission's latest guidelines, healthcare fraud, mortgage fraud, child pornography, all of those I think are up. Crime is down on the crime that the FBI and others pay attention to, violent crime, property crimes, and that's not covered in the federal system much, if at all. And so, true, there may be a reason to think, because the federal system did an incredible job of pulling in repeat offenders through a variety of broad statutes and incapacitating maybe some of the worst, and I don't want to undersell the significance that that might have. But there's also a kind of unfair disconnect. I think you're right politically. Crime is down so people aren't turning it into a political issue. But you're wrong to suggest that that is why the federal system must be working well, or that it's itself a sign that Congress, who knows what Congress is up to, that's the joy of our system. If they can't get their act together, we leave the status quo in place, and if they can't get their act together, that may be itself a sign that the status quo is good enough for government work. I certainly think it is.
And I'm going to give, now we're going to have to wrap the panel up, so I'm going to give everybody, and I mean everybody, 1 minute. I'm going to put a hardcore press on it, keep it to 1 minute, to give the audience some final thoughts.
One of my final thoughts is thank you for throwing this interesting discussion. I don't know whether Congress is going to do anything or not with it. I do know that we are 6 years from Booker, and we are at a turning point in some ways in sentencing because of the decrease in violent crime, but also because of the mass incarceration right now. It's a point to start talking about sentencing again. The Commission, to go back to our original theme, is right in the middle of this. We're at the crossroads of what's going on. We care intensely whether it's about crack. In fact, street crime is a huge part of what we do. Guns, drugs. Our 28% of the caseload last year was drug. 10% or so was firearms. The only thing that's bigger is immigration. We are right in the midst of this debate, whether it's on disparity or it's on severity. And I think that this is something on both of those fronts that we need to work on, and I just promise that we'll be in the middle of it and get from it.
Professor Berman?
I want to bless Mike's instinct to have a simplified system, though I want to bless that against the backdrop of what makes the system so complicated is a false severity precision, right? Having to define the exact amount of crack or powder itself is a road to madness, let alone trying to figure out exactly how many images somebody got from LimeWire or how much loss is exactly involved in an offense. And it's not just a story of it's crazy that Mike needs to have 3 trucks to bring it in. That much law heightens disparity that's even more hidden than others. It provides a mechanism not for, I think, inappropriate subterfuge, but for really well-meaning lawyers doing their darndest to take advantage of gaps in the system and uncertainty in the system that doesn't even show up on a data sheet any way, shape, or form. So I think simplification is exactly the right starting remedy. And again, to me, the easy thing is eliminate a third of the enhancement. I don't think you change the sentencing structure in any significant way. I don't think Congress would notice that much as long as you pick the right ones. And I think that would be the first great step to making the system work a lot better.
I never thought I'd say this, but I agree with everything Doug said. But second, I think there's also another important, and this is a different issue, but it's one of my pet peeves. The criminal code itself has to be cut down by a third, and we were working to do that when I was there. And I know that they're still continuing that effort. It's ridiculous. That is another ridiculous document. It's way too thick, and you might as well call it the tax code. The Sentencing Commission's guidelines have to be cut, and the whole their assignment needs to be modified. I will end on a more positive note, which is that the one and most I think effective model for how things can get done and be helpful in D.C. is on the reentry issue. I think the Second Chance Act, and I think the fact that judges are getting more involved in that, I think is fantastic. I think it brings both sides together because you sell Republicans how? You say, hey, it's cost effective. You're going to reduce the amount of money. The Democrats love it because they love it. Okay? They like these types of things where that people aren't being punished really hard. And so I think it's a very good thing. And I think it's a model for how you can do other things in this city and in the Judiciary Committee and at the Sentencing Commission. That to me is exemplary. And one thing I will say, the federal the federal reentry program, we viewed it as a model for what the states hopefully could get to, because their recidivism rate in the federal system is in the 30s, as opposed to the 50-60% that we hear in the state system. That to me shows that there's some good work being done, and I applaud the judges and the commission for everything they've done in that area.
Amy?
Well, I would say that simplified guidelines have come to mean mandatory guidelines. So I don't agree. I think that the guidelines manual could be simplified, but there's no need to make them mandatory, because what comes with making them mandatory is no balance, no more judicial feedback to the commission, because as Judge Saris was saying, and I don't know if everybody understands this, but judges wouldn't even be finding the facts that set the range. They'd really just be sort of a clerk to, put their stamp on the sentence, and it would be not good. Yes, so we should be selling Congress on how much those 14,000 years of saved time in crack and career offender cases, how many prison beds at 28,000 a year saved.
Thank you, Amy. And the entire panel. I want to introduce Laura Murphy, who's the director of the Washington Legislative Office, to come up and give some closing remarks. Thank the audience also for hanging in there.
I'm just really struck by the absence of passion on the panel. Oh my gosh. I mean, it reminds me of Crossfire. Anyway, I want to thank the American Constitution Society for partnering with the ACLU to put on this very, very dynamic panel. And I just want to say that the ACLU takes these issues very, very seriously. And I want to make sure that Navita Gupta, who's head of our Center for Justice, stands up and raises her hand. She has been putting all of our resources together to help deal with the over-incarceration problem. And she's moved to the ACLU Washington office, and we're really from New York, and we're really glad she's here. And, the ACLU is passionate about these issues, and we are, the biggest deprivation of liberty is, putting somebody in jail or giving them the death sentence. And so we've struggled with these issues our entire 91-year history. And I personally am very passionate about these issues because they were discussed around the dinner table. Both my father and brothers were judges. They were the first father and son judges in the United States at the state level. And when Judge Howard was made a federal judge from the state of Maryland, he commissioned a review of sentencing policy that was part of my father's most treasured personal effects when he passed away. And so the fight for a fair judiciary is in my DNA, and it's in the ACLU's DNA, and we commend the panelists for being so passionate and helping us be better informed. And I commend all of you for staying hours to hear this discussion. And obviously it means there's a community in Washington that needs to continue to work together nationally and locally to change these very, very unjust policies. So thank you very much. And we hope you come back soon.